Welcome to the deep dive. Today, we're really getting into something quite specific, but honestly pretty important in the legal world.
hmm
We're looking at Amicus Curiae, basically, friends of the court, and their role specifically when it comes to the High Court.
Exactly. We've got this great article that's analyzed their involvement, looking at the pros, the cons, um, and what it all really means for justice.
Yeah. And our mission, as always, is to kind of unpack all that, pull out the key insights from the source material for you.
Get straight to the core arguments.
Okay, so first things first. Maybe not everyone listening is, steeped in legal terminology. What is an amicus curiae, roughly?
Right. So think of them as a neutral third party. They're not directly involved in the lawsuit, like the plaintiff or defendant,
Okay.
but they have some kind of special knowledge or expertise about the subject matter of the case. Their whole point is to, well, assist the court.
Assist how? Like giving evidence?
Not usually evidence in the traditional sense. It's more about offering unique perspectives, uh, legal arguments, maybe broader context that the actual parties in the case might have missed or, didn't focus on.
Gotcha. Helping the court see the bigger picture, maybe?
Precisely. To help ensure a more informed decision, ideally.
So, why should you, listening now, care about this? Well, look, if you want to understand how big legal decisions get made, how high courts actually think,
Hmm.
then knowing about these friends of the court gives you a sort of deeper insight. It shows the different factors that can come into play beyond just the main arguments.
Yeah, absolutely. Because the high court isn't just settling disputes, right? It's also making law, shaping how laws are interpreted.
And Amici can potentially influence that.
They can,
Yeah.
by bringing in those different viewpoints, that specialized knowledge,
Yeah.
things the court might not have heard otherwise. It can, nudge the way the law develops.
Okay, this is where it gets particularly interesting for me. The article we're drawing on didn't just talk theory, it actually looked at the data.
It did. It surveyed high court cases between 2010 and 2022, a pretty decent time frame.
So what did they find? How often are these friends actually showing up?
Well, it's maybe less common than you might think. Over that whole period, 672 cases were filed. Amici were admitted in only 47 of those.
47 out of nearly 700. That's
Yeah, just under 7%, 6.99% to be exact. And it wasn't steady.
how so?
Like in 2010, it was up at 12%, but then by 2020, it had dropped way down to just over 2%.
Wow, quite a dip.
Yeah, though it did tick up again more recently, like in 2018, 2019, and 2022. So there's definitely some fluctuation there. The court's approach seems to vary a bit over time.
Okay, so not happening all the time, but it's definitely a tool the court uses sometimes. Let's talk about why it might be valuable. The article makes a case for maybe using it more. What are the main benefits?
Well, one of the biggest arguments is preventing a failure of justice.
How does that work?
Because an amicus might bring forward some really crucial piece of information, or maybe a legal angle, that the main parties just didn't see or raise. They can highlight things vital for a fair outcome.
And the article gave an example, right? Something about cultural differences.
Yes, exactly. It sketched out a scenario where maybe an accused person faced disadvantages during police questioning because of cultural or linguistic barriers,
Right.
things that maybe weren't fully understood or presented by the defense or prosecution. An amicus with expertise in that area could have highlighted that for the court.
Which could make a huge difference to whether the trial is actually fair.
Absolutely. It's about making sure those potentially hidden factors are considered. It could prevent a real miscarriage of justice.
That's powerful. Okay, what else? Any other benefits?
Another key point is about the court's legitimacy.
Legitimacy. How so?
Well, the thinking is, if the public sees the court actively considering a wide range of views, expert opinions, societal interests, not just the arguments from the two sides, it can build trust.
Makes sense. It looks more thorough, more connected to the real world.
Kind of, yeah. It shows the court isn't operating in a vacuum, that it's taking a broad look, especially on big, important cases. Having input from, say, relevant expert groups might make people feel the decision is more grounded.
Okay, building public confidence. And there was another point about balancing interests, something about non-governmental voices.
Right. Sometimes, especially in cases involving the government, you might worry that the government's perspective could dominate.
Yeah.
Amici can provide a platform for other interests, community groups, NGOs, academics to present their views, offering a counterweight.
So it prevents one side, potentially a very powerful side like the government, from having the only say on the broader context.
That's the argument.
Yeah.
And some people mentioned in the article feel that being too restrictive on allowing these voices could actually be While wasteful, you're potentially shutting out valuable knowledge.
Okay, so preventing injustice, boosting legitimacy, balancing interests. Sounds pretty good. But inevitably, there must be downsides, right? Or at least concerns.
Oh, definitely. The article lays out several potential drawbacks. Practical ones, mostly.
Like what?
Well, the obvious one is workload and cost. More submissions mean more reading for the judges and court staff.
Yeah.
That takes time, costs money. It can slow things down.
Right, the wheels of justice might turn even slower.
Potentially, yes.
Yeah.
And then there's the issue the article calls inequitable amicus appearances.
What does that mean? Like, it's not fair who gets to be an amicus.
Sort of. The worry is that well-funded groups, big corporations, or established lobby groups might have the resources to prepare fancy amicus briefs,
Uh-huh.
while smaller groups, community organizations, maybe representing less powerful interests, just can't afford to participate in the same way.
So you might end up hearing more from the groups that already have a loud voice.
That's the risk. It could create an imbalance in the friendly advice the court receives.
Okay, that's a serious concern. What about the effect on the actual parties in the case? The ones suing and being sued?
Yeah, that's crucial too. Imagine you're one of the parties, and suddenly an amicus introduces a whole new line of argument, maybe late in the day.
You might not be prepared for that.
Exactly. It could feel unfair, like you're being blindsided. You might not have a proper chance to respond effectively.
And could Amici have their own agendas, even if they're meant to be neutral?
Well, the article does raise that possibility. There's a risk, perhaps small but real, that an amicus might try to subtly push a particular outcome, introducing a potential bias, despite the neutral helper role. Ulterior motives, basically.
And you mentioned slowing things down earlier. Delay is another point.
Yes, just the simple fact of adding more steps, filing amicus briefs, allowing responses can stretch out the whole timeline of a case.
Okay, so it's definitely not clear-cut. Real benefits, but also real potential problems. Workload, fairness, bias, delay.
It's a balancing act.
Which leads perfectly into the next bit. How do you strike that balance? The article suggests specific criteria for deciding when to let an amicus in. What are they?
It boils down to three main things, according to the article's analysis. First, the amicus needs to offer unique assistance,
Unique. Meaning what exactly?
meaning they bring something genuinely new to the table. A perspective, some data, a legal argument that the main parties haven't already covered. It shouldn't just be repeating what's already there.
Right. Adding value, not just volume. Makes sense. What's number two?
Second, they need to have a genuine interest in the question before the court.
Okay, so not just someone who finds the case vaguely interesting.
Exactly. It suggests they should have some real stake in the legal issue or its potential impact. It shows their involvement is serious and relevant, not just, academic noodling.
The demonstrable connection. Got it. And the third criterion?
The third one is basically a cost-benefit test. Do the potential benefits of hearing from this amicus outweigh the potential burdens?
Ah, so weighing up the value of their unique insight against the extra workload, potential delay, and cost we talked about.
Precisely. Is that practical check? Is it actually worth it in this specific instance?
Okay, those seem like pretty sensible guidelines. Unique help, genuine interest, and benefits outweighing the costs. Did the article look at how this actually works in practice, like specific cases?
It did touch on that, yeah. Discussing the theory in practice, it pointed to situations where arguably amici should have been admitted, but weren't.
Like when?
Often in cases involving really novel or complex areas of law. Think cutting-edge science or maybe international law issues, places where extra specialized expertise would clearly be helpful.
Give the court more tools to work with complex stuff.
Exactly. The article even mentioned the European Commission sometimes acting as an amicus in international courts as a kind of model for how valuable that expert input can be.
Interesting. But it also said sometimes denying leave was the right call.
Yes, absolutely.
Yeah.
It acknowledged cases where refusing an amicus was justified. Maybe their proposed arguments were totally off topic, irrelevant to the core legal question.
Or just repeating what the main parties already said.
Or just repeating things, yeah. Which goes back to that first criterion, uniqueness. If they're not adding anything new, then admitting them just adds clutter and potentially delay. So applying the criteria works both ways.
Right. It's about applying those principles consistently. Okay, so let's try and pull this all together. As we wrap up this deep dive, what's the main thrust of the article's argument about amici in the High Court?
I think the central message is really a nudge towards a more liberal but still principled approach.
More liberal meaning letting them in more often.
Essentially, yes. But not just opening the floodgates. It's about applying those clear criteria we discussed: unique help, genuine interest, cost benefit thoughtfully and consistently.
So the idea is if those criteria are met, the court shouldn't be overly hesitant.
That seems to be the gist. The argument is that the potential benefits preventing injustice, boosting legitimacy, balancing interests are significant enough that a certain cautiousness shouldn't become like an automatic no. If an amicus genuinely offers value according to the criteria, let them contribute.
It's a call for openness, guided by clear rules. Really fascinating how these behind-the-scenes players can potentially shape things.
Definitely.
Okay, so to leave you with something to think about, how might things change if high courts became much more open or perhaps even more restrictive about allowing these friends in? How could that fundamentally alter how they work and maybe even the kind of justice that comes out?
Yeah, and a related thought.
Hmm.
What responsibility do experts, people with that specialized knowledge out there in society, have to step up and offer it to the courts, even if they aren't directly involved in a case? Is there, like, a civic duty there?
Good questions to ponder. That's all we have time for on this deep dive. Thanks for joining us.